Good morning, namaste, and welcome on e-platform of Faculty of Law, GLS University. We are so glad that we are having with us Mr. Edgardo Sobinas Obregon with us, sir, who is a consultant in public international law. Sir is a president of International Law Association, also a founder of Nicaragua chapter, as well as a legal practitioner at International Court of Justice, Hague. On 21st September, world celebrates the International Peace Day. And Sir has kindly consented to deliver a lecture on peaceful settlement of international dispute, negotiation and judicial settlement. Peaceful settlement of international dispute is a fundamental principle of international preparatory chapters. And we are very thankful and grateful to Sir that he has kindly consented. On behalf of Faculty of Law, GLS University, on behalf of Director of Faculty of Law, GLS University, Dr. Mayuri Pandya, who is a member of Expert Appraisal Committee, Ministry of Environment and Forest and Climate Change of Government of India from Delhi. Ma'am is also a member of State Expert Appraisal Committee from Gujarat, Gandhinagar. Ma'am is also a member of Environment Appellate Authority, Department of Environment and Forest, Government of Gujarat, Gandhinagar. She is also co-chair of Intellectual Property Rights, Gujarat Chamber of Commerce and Industry. Ma'am is also a member of Legal Subcommittee of FICCI, Gujarat State Council. On behalf of her and Faculty of Law, GLS University, we are welcoming you, sir. Thank you very much. Sir is an international lawyer, arbitration and litigant. Sir is an international lawyer with an extensive experience in international litigation before the International Court of Justice and unique practice in coordinating and managing international legal teams. Sir's consultancy practice focuses on issues concerning public international law, international dispute, and procedural support. Sir is also a founder and president of International Law Association, Nicaraguan branch, and also litigant at International Court of Justice. Sir also offers an integral legal training program that aims at improving states' legal capacity and procedural understanding of international litigation, both from state and international courts' perspective. Sir deliver different guest lecture globally on the topics relates to international law and international litigation. He is an author and co-editor of the book Nicaragua before the International Court of Justice, Impact on International Law. Sir's forthcoming book is Environment Through the Lens of International Court and Tribunals. Sir is also an author of many articles, chapter, and podcasts. Sir, we are welcoming you at on e-platform of Faculty of Law, GLS University. Our students are very eagerly awaiting for this knowledge enriching session. So, without wasting much time, over to you, sir.
Well, thank you very much, and good afternoon. First of all, of course, I would like to thank the GLS University for the kind invitation, especially to Professor Giga Matarani for contacting me and inviting me to give today's presentation on the peaceful settlements of international disputes with a focus on negotiation and judicial settlements. So I think that I'm going to talk for about 40 to 45 minutes, and afterwards we're going to have the opportunity to have a short session of questions and answers. So let me start first with Article 1, Paragraph 1 of the UN Charter, which recognizes, as you know, as one of the purposes of the United Nations, as the maintenance of international peace and security. To secure precisely this purpose of the United Nations, these articles indicate that the members should take effective collective measures for the prevention and the removal of threats to peace, for the suppression of acts of aggression or other breaches of the peace. And more relevant to today's presentation, it states that its members should settle their disputes by peaceful means and in conformity with the principle of justice and international law. So in other words, the members of the United Nations, the states, the international community must refrain from resorting to the threats or the use of force against any other states, against their territorial integrity, and against their political independence. And they have to settle their international disputes by peaceful means in such a way that they do not endanger international peace, security, or justice. The question then is, what are these peaceful means that are referred in the Charter of the United Nations? Well, clearly, we have to clarify first that peaceful means are all of those that do not lead to the use of force or the threat of the use of force. However, I'm going to focus on Article 33, Paragraph 1 of the Charter of the United Nations, which details some of the mechanisms that are available for the member states. So Article 33, Paragraph 1 of the Charter states that the parties to any disputes, the continuance of which is likely to endanger the maintenance of international peace and security, shall first of all seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice. So as I said before, we are going to focus on two of these means, which is negotiation and judicial settlement. And I would like to emphasize at least 4 points here. The first point is that this provision appears, in principle, to establish that the parties are subject to a binding legal obligation to seek a peaceful solution to their disputes. This is clear in the text in English and in French. It's not as clear in the text of Spanish, but we know and it's well established that it is an obligation, and that such obligation exists and consists of trying to find peaceful solution to any conflict. Second, the parties can use the mechanisms mentioned in Article 33 to resolve any type of controversies, even when the continuation of the controversy or a dispute in principle does not endanger international peace and security. Bear in mind that the article says likely to endanger. So a clear example of these are the cases, for example, of maritime and land delimitation that are filed to the ICJ, the International Court of Justice, through the notification of special agreements between two or more states, which over time have shown that they do not necessarily represent a danger per se for the international peace and security. Now, the fact that a conflict does not represent state danger does not mean that it is very important to consider that its own existence can and may affect or impede the advancement or bilateral or regional agendas that in the short or in the long term could affect bilateral or regional relations, or that this type of conflict can prevent the use of resources located, for example, in the maritime areas, an element that I will try to address later today in my presentation. A third point, it is important to note that there is a majority of authors who argue that Article 33 constitutes a detailed elaboration of Article 2, Paragraph 3 of the Charter. However, if we take this into account, the question is then why Article 2.3 speaks about international disputes and Article 33 refers to any disputes, which is likely to endanger the maintenance of international peace and security. This discrepancy can be partially explained by the specific function of Article 33, which describes the disputes resolution mechanism as a preliminary stage before they can be referred to the Security Council or the General Assembly if it is needed. In other words, and as can be seen from the phrase first of all, the provision considers the connection between the responsibility of the parties involved in a dispute and the responsibility of the organization, the United Nations. This emphasizes that it is up to the parties themselves to take corrective measures regarding their disputes, and in the cases where this is not effective or this is not enough, the procedures of Chapter 6 or 7 of the Charter can become applicable. On this point, it's also important to clarify that the apparent differences between Articles 2.3 and 33.1, meaning again that 2.3 recognizes international disputes and 33.1 refers to any dispute, should not be understood to include internal disputes, 33.1. The practice is clear on this point. And such a practice is also reflected in paragraph 7 of Article 2 of the Charter, which prevents the United Nations, and of course its member, from intervening in matters that are essentially within the internal jurisdiction of a state. A fourth point that I would like to raise is the available mechanism. You know, the judicial settlement constitutes only one of the means of the mechanism available to the parties for the resolution of their dispute. This alternative nature was emphasized already by the Permanent Court of International Justice even before the Charter was adopted. In 1929, the PCIH stated that the judicial solution for international disputes is simply an alternative to the direct and amicable solution of such disputes between the parties, meaning the states. It is true that this article gives an initial impression that the parties to a conflict are obliged somehow to try all the procedures or mechanisms that are indicated therein. However, this is not correct. On this point, it is important to recall the decision of the International Court of Justice in the case of the land and maritime boundary between Cameroon and Nigeria, where it recognized that there is no obligation under international law to exhaust diplomatic negotiation before referring a dispute to a judicial body. This echoes the principle of free of choice of the states in the exercise of their sovereign rights to decide where and how to decide or solve their international legal disputes, which also relates to the well-known principle in international law, which is the principle of consent. Perhaps it is important to note here that the certain mechanisms that I mentioned or that are included in Article 33 may not be available for the states to choose in specific circumstances. So, especially when there are preconditions to the activation of the jurisdiction of a specific tribunal or court, or when the conflict is of a special nature that can only be subject to the jurisdiction of a specific tribunal or court. So yes, there are many mechanisms that are available for the states. They are free to choose, but there might be some limitations concerning the jurisdiction of the courts in respect to certain type of conflicts. In relation to the order in which the mechanisms are indicated in Article 33, it is important to emphasize that said order does not represent a progressive line that must begin with negotiation and must end with judicial process. No. These mechanisms, all of them, are alternatives available to the states to be used to the extent that they are most beneficial for the parties in finding an appropriate solution to their conflicts in an effective and satisfactory manner. Additionally, it is essential to mention as well that the mechanisms are not mutually exclusive. So, for example, in the case of genocide and the agency between Greece and Turkey, the court clearly determined that there is a compatibility between two or more mechanisms when they are activated in parallel. As a matter of fact, the court, the ICJ I'm talking right now, encourages in somehow the negotiations, encourage that negotiation should take place parallel to the process, with the intention, of course, of solving the conflict in the most effective way possible. In the Bosnia genocide case, negotiations, mediations, and conciliations were running parallel to the process before the ICJ. And all of these were aiming at the same point, to find a peaceful solution to the conflict. And this accumulation of means did not prevent the court from exercising its jurisdiction and resolve the dispute. And another example, as I just mentioned, is the case of agency, in which the court also recognized that carrying out negotiations simultaneously with the proceedings, that's the proceedings before the court, did not constitute, legally speaking, an obstacle for the court to exercise its judicial function. So now you must also keep in mind that the negotiation of a conflict, we're talking about negotiation, is in any case a continuous process that should not be ruled out once litigation has begun before any court or international tribunal. In any case, if anything, it will be the opposite. It must persist. What I'm saying here is that simultaneously to the litigation process, the parties, the states, must also dedicate energy and resources to parallel negotiations. In principle, one must not lose sight of the general objective, of the general vision of all the conflict and the dispute. And that is the desire to finally find a solution to the conflict that exists between the two states. So with this general image, with this general picture, I would like to focus a little bit on negotiation right now. As you know, negotiation is a technique, or is the technique par excellence to solve any dispute between states. This is due in large part to the control and flexibility that it provides to the states that is negotiating a conflict with another state. But it is also because it has a bigger scope. So it can offer the opportunity for the states to include elements and arguments that are not necessarily legal in nature, something that in principle wouldn't be possible in a proceeding before an international court and tribunal. Negotiation is also the first natural step to find a way out of any dispute with another state, and the most advisable technique from a strategic point of view, if it is used well. And I would like to make a small pause, a short pause here, and explain why do I say that it is a very good technique and perhaps the most advisable technique, but only if it is used well. To understand this, it is important to first clarify a little bit more of the elements of the characteristic of a negotiation process. So, negotiation, as you know, is a technique based on an exchange of position that aims to reach an agreement or resolve a dispute, and where the parties do not have identical interest, but share the ultimate goal, which is to reach an agreement. So as we know, negotiation can take place in a bilateral or multilateral context, and our focus here, of course, is precisely bilateral context between states. The negotiation can be divided in 3 different steps. The first stage will be the diagnosis stage, which is also sometimes referred as the pre-negotiation phase. And what it is necessary to establish, the parties have to establish what the conflict is, what is the conflict about, and what is to be negotiated, and what is the main objective that they want to achieve. The state must also clarify those points that are not negotiable and be clear on their mind on the points that they can give concessions. The second stage refers to the formulation, where the points of agreement, disagreement are determined and are expressed to each other. And the final point will be the specification phase, which is pretty much the drafting of the document that will be eventually and potentially signed by the parties of the negotiation. So perhaps on the first point that need to be mentioned is that from a practical point of view, through all these stages, negotiation in itself is an institution of international law. And it is a meeting point between diplomacy and international law. It is also necessary to be clear and say that negotiation can definitely mark the beginning of a peaceful agreement between the parties, but it can also mark the beginning of a more complex dispute, or even a new kind of dispute. If the negotiation marks the beginning of a dispute, it is in a way of crystallizing a dispute that they didn't know it existed before, and this will be referred at this precise moment when that happened. It's known to be in legal terms as the critical date, which is the one that defines the day, the beginning of a dispute. In what sense? In the sense that the dispute and conflict may not yet be defined at the time that the negotiation process started. And it is precisely in the process of negotiation where the points of conflict arise and are manifested and become the moment which the parties, meaning the state, actually realize that there is a legal conflict between them. Then the negotiation process becomes a decisive point in time, legally speaking, because it instead of resolving a dispute, it pretty much clarified the element of a legal dispute that exists in between the parties. Now, also in practice, the negotiation process allows the parties to obtain additional information from the counterpart. It allows a better understanding of the position of the parties. It allows to understand what actually the claim are. It allows to understand what the strategy could be. And of course, this is a two-way line. So both parties will gain that access. Both parties will get that first impression of what is the real interest of the counterparty. So that is why anyone or any states or any legal advisor that is going to a negotiation process should have a clear mind and should have well analyzed, of course, the strategy before going into any negotiation, because all of this will take part. What I'm saying is that both parties will gain a clear access to what the real position of the other party is. As I said before, you can reach an agreement with the other party, but you can also start or crystallize a new dispute that they didn't even know that existed before. So it is important for all you to keep in mind that the objective in general, the principal objective of negotiation shouldn't be, I have to be careful here, but shouldn't be to obtain 100% of the preconceived claim or positions that you have when you enter a negotiation room. This is because the very nature of negotiation requires concessions. Otherwise, it wouldn't be a negotiation, but it will be an imposition of the will of one of the parties. It is also vital to remember that claims, interests, positions mutate throughout the negotiation process. Undoubtedly, each day of negotiation brings new elements to the table of the parties, and each day of negotiation can alter or varies the context that you were negotiating with the other party. So certainly certain flexibility, creativity, it's welcome in any process of negotiation. In any case, what truly matters is to obtain a satisfactory result from the eyes of the people of the state that are negotiating. So, which doesn't necessarily mean, as I said before, to obtain 100% of the claim. Perhaps if you listen to the other party and there comes a solution that is more beneficial to both of them that you as a negotiator didn't preconceive before, it doesn't mean that you shouldn't accept it. So you should be a little bit more flexible and try to open the image a little bit larger to see the big picture and see what the benefit could be if you adopt this or that point of negotiation instead of what you consider to be the best solution. Perhaps some of you have read, I don't know, Chris Voss. He's a master of negotiation. And Chris believes that the art of negotiation is based on finding precisely common grounds with the others, making concessions, and demonstrating emotional intelligence and tactical empathy. This and the other basic principle of negotiation are the key, actually, to making a negotiation a win-win situation to all the parties involved. In addition, if the parties feel satisfied with the result, then we will also have taken a positive steps for the next phase, which is the implementation process, the implementation of the agreement. This phase is not much different from the post-judicial phase that you would have if you receive a judgment from an international court of tribunal, given that the conflict or a dispute does not end with the signing of an agreement and doesn't end with the issuing of a judgment. Conflicts end with the implementation. The agreement or the judgment simply represent the completion or the end of the process, be it litigation or negotiation, but not the end of the dispute. So it's up to the parties to actually accept it and implement the result that they have achieved through any of the mechanisms that they have available. Regarding the benefits of negotiation in political and legal terms, it can be mentioned that they demonstrate a political will. Negotiation clearly demonstrates a political will of the parties to be able to settle the disputes, which is also crucial for the implementation phase that I just mentioned. Negotiation also allows the inclusion of factors and elements, as I said at the very beginning of the presentation, that are not necessarily legally in nature, but of great political, economic, and cultural importance for the parties, which, again, to a certain extent, would not be considered in isolation as a single unit by a judicial argument when deciding a legal dispute. So of course, you can argue from a political, economical, cultural stand, but it will have to be linked to certain legal arguments. Otherwise, a judicial organ wouldn't decide on a political issue, solely a political issue. And negotiation allows that. So you can actually argue only on political basis, and then you might be able to reach a political agreement. Additionally, we can mention the negotiation are diplomatic processes that allow states to accept or reject any result that they obtain, which is not the case, again, with a judgment, for example, from the ICJ, which we know are final and binding and have the force of res judicata between the parties. It is also significant to know that negotiation allow the parties to control the message that they want to convey to the international community and its own citizens. So this freedom as well can be achieved through also or as part of the negotiation process between the parties, what they would like to communicate the international community once an agreement has been reached by the parties. From a financial point of view, negotiation could also represent considerable saving funds since the parties do not incur in the high cost of international litigation that sometimes, not always, but sometimes characterize the processes before the ICJ, before ITLOS, or an arbitral tribunal. Although, as I have to say, this is not always the case. I'm not going to go into detail of financial aspect of proceedings, but it is an interesting topic. But I have to say that it is not always the case. And also, you must consider that if we put negotiation against litigation, you have to understand, or you have to think about it and realize that sometimes negotiation process has been on the table for decades or years. And this also represents a high cost. And perhaps more importantly, it also represents a heavy and undesirable political and social burden. Furthermore, if the negotiation is about maritime and territorial areas, for example, if the negotiation is over maritime and territorial areas that have resources, then the economic impact of not reaching a solution with the other party also affects the exploration and exploitation of these areas, which represent a high cost. You are not making the benefit that you could have if you reach a solution with the other party. And if negotiation doesn't allow that, then it might be better to go to litigation to try to find a solution instead of not expending those amounts, those resources, in trying to actually get access to all these resources that are laying there in the maritime areas. So what I'm trying to say here is that sometimes litigation is actually the less expensive option. Finally, we have to understand that negotiations contain a high political element in addition to the legal one. And that is why it is not always the most effective option to resolve a dispute to the satisfaction of the parties. In these cases, and especially when there is a legal certainty on your claim, if you are an international lawyer advising a state and you have certain legal certainty, then some state tends to opt for the judicial route. They feel comfortable in going to litigation or before a permanent or an ad hoc tribunal. And now I would like to move to the judicial settlement. But before examining the advantages or disadvantages of the judicial settlement as a technique to resolve an international dispute between states, it should be remembered that litigation should not be adopted in isolation from the position of the other party, in the sense that it is vital for the state that has the intention to initiate a procedure against another state to be fully aware of the position of the other party on any of the mechanisms that are available to solve an international legal dispute. As can be expected, as you can imagine, the selection of the appropriate mechanism, which in principle will be accepted by both parties, could have a positive effect on the bilateral relations and the resolution of the dispute. Since in principle, we could anticipate that the parties will accept the adopted mechanism, take part of the process with the real intention of actually solving the conflict. Depending on the nature of the dispute, a correct choice of the mechanism will in turn reduce any tension between the parties, will strengthen bilateral relations, and will facilitate the implementation of the agreement or the decisions obtained by the international court or any other international court tribunal, which is why it is vital for the states that intends to initiate a procedure to know the position of the opponent on the various mechanisms on peaceful settlement of disputes. If, on the contrary, one of the parties to the dispute decides to proceed in a way that it is known, it is fully aware that it's not of the liking of the other party, then perhaps the conflict or the bilateral relations will be affected and even aggravated. This is what happened to a certain extent in the arbitration in the South China Sea, in which the Philippines initiated an arbitration against China, knowing that China, being fully aware that China was not going to participate in the proceedings, nor China will accept or implement the award of the arbitral tribunal. This was expressed by China and confirmed by recent history. In this case, China openly said that it considered the ruling in favor of the Philippines from the Permanent Court of Arbitration to be void and non-binding, and assured that the country will not accept it or recognize it. So this is not to say, of course, that the Philippines should not have initiated the proceedings against China. This is a sovereign decision of each country that correspond to its own legitimate and well-founded interest. I have nothing to say. No one has anything to say about that. This is a sovereign decision of the Philippines. What I'm saying here, and my point, is that if a state initiates a proceeding against another state, knowing that it will not participate, or will feel abide by the decision of the arbitrary tribunal in this case, then you will face implementation problems, which could eventually even worsen the conflict or the relationship between the two states. This, of course, does not contradict that under certain circumstances, the judicial or the litigation route is the only option that you have, especially in cases where the dispute cannot be solved by other mechanisms, including those contained, apart from litigation, of course, in Article 33 of the UN Charter. Either because of these mechanisms or techniques have been exhausted, or because they are not viable. In any case, states must always weigh the advantages and disadvantages of losing control of the bilateral dispute resolution process, which will be negotiation, and the advantages and disadvantages of reaching a solution through a judicial process. One of the main practical characteristics that should be emphasized here is that when the conflict is resolved before a judicial body, the state loses, to a certain extent, control of the dispute resolution process. As you know, it is the court and the tribunal, the one that will eventually decide the conflict based on an objective interpretation of the evidence that is submitted by the parties and the implementation and application of the applicable international law. So the states pretty much remove the responsibility of solving a dispute and put that responsibility on the shoulder of the international court or tribunal. So with this in mind, what are the advantages of the judicial settlement? Well, several. First, an international litigation process offers the opportunity to focus on the law as the means to solve a dispute and prevents other interests from prevailing. This is especially true and relevant, especially in disputes between states that have strong capacity, let's say for diplomatic influence, and those that do not have that capacity, or between states that have important difference in terms of income, GDP, or military capacity, for example. All these disadvantages or disbalances between states could and normally generate additional pressure during the negotiations, which actually result in unbalanced result. Example of this, and this is just assuming that this could be the case, for example, or be reflected in the cases of Ukraine versus Russia, that you have, okay, Russia, Ukraine maybe would like to focus more on the legal instead of the other means to try to reach an agreement. This could be the case between Palestine against the United States, Palestine fighting against the United States, Iran versus the United States, Iran filing a case before against the United States. All of these cases are before the International Court of Justice. So second, the litigation of a dispute can result in a full recognition of the claims of a state, as this has been already demonstrated in the case law of the court, for example. It is possible to obtain an absolute victory through an international judicial process. And this was the case of the territorial disputes in relation to sovereignty over Pulau Ligitan and Pulau Sipada between Indonesia and Malaysia, where the court, meaning the ICJ, recognized 16 votes to 1 that Malaysia has sovereignty over the islands that were under disputes. So as you can imagine, getting the totality of a claim is unlikely in a negotiation process, where concessions, as I said before, are a sine qua non element. So you have to concede to certain points or claims. Therefore, before making the decision to litigate, it is necessary to make a meticulous analysis and an evaluation of the claims of the states, the national interests that are at stake, and measure the relative gains that can or could be achieved through litigation, both politically and legally speaking. Also, and of course, as much as an absolute victory is possible, a partial or a total loss of the claim of a state is also possible. However, and to the initial surprise of some of you, it is not so unusual that under certain circumstances, a government actually decides to refer a lost cause to an international court and tribunal, especially when they consider that such sacrifices are essential to resolve the controversy. This happened, for example, when the government is aware that the national public opinion will reject any bilateral agreement with the other party if it does so directly, or when a government knows that in advance that the parliament or its Congress will not ratify a bilateral agreement with the other party. These situations are more common when there is a historical enmity between the parties to the conflict, and when the conflict has acquired a historical value for both parties. And therefore, the political cost is too high. So it is precisely this aspect that leads to a third advantage of judicial settlement, which is the resolution of a historical controversy. A clear example of in which one of the parties was aware that it would not obtain a total victory in their favor, but decided anyway to go to the judicial route, to the litigation path, by the signing of a special agreement, is the case of Libya-Chad. In 1989, Libya and Chad signed an agreement when they submitted a dispute over the Aso Strip to the ICJ. The Aso Strip is a large territory located between the two countries, which at the time was devoid by any proven exploitable resources, for which its economic importance was not of great relevance to consider at the moment of litigation. But despite this, the conflict over this strip of land between the two countries continued for decades, which affected, of course, the relationship between both states, between Libya and Chad. So Libya, for its part, was aware that its position was legally untenable, and I'm quoting here, legally untenable, so I'm not arguing that. It was written by some of the lawyers that were working for Libya at the moment, that it was legally untenable, but by accepting that the dispute be resolved by the ICJ, it contributed to putting an end to a decade-long dispute. And also, this is important to say, so on the one side, it put an end to a long decade dispute between both of them, and at the same time, Libya emerged in the international community as a country that was respectful of the rule of law, because it used the International Court of Justice, it accepted the jurisdiction of the International Court of Justice to actually solve an international legal dispute it had with Chad. Another example in which the main interest was not obtaining an absolute victory, but ending a controversy to a judicial body, is the case of the Gulf of Maine between Canada and the United States of America. The conflict consisted of a maritime delimitation dispute between the parties, and it has been stated that neither Canada or the US was in a position to give concessions without them having a negative impact or perception by their citizens. So by attending the court, I'm talking about the International Court of Justice, both countries removed, as I said, the responsibility for concessions from their governments and placed, say, that responsibility on the ICJ. During the proceedings, both parties presented and, of course, defended their claims based on national interest. In the end, and since the case would be resolved by a judicial body, the government demonstrated, both Canada and the United States, demonstrated to their citizens that they did not give up sovereignty. On the contrary, they defended their interests in the best way they could. But in the end, as a state respectful of the rule of law and international law, they had to respect, accept, and implement the ruling of the ICJ. So these two cases are examples in which the parties decided to submit their disputes through special agreements to the International Court of Justice, not with the intention of obtaining an absolute victory, but with the intention of achieving an end to a conflict or conflicts that prevented them to advance their bilateral agendas and also to improve their relationships. In doing so, both states removed the responsibility for concession from the governments and placed the responsibility on the ICJ. And this is the last aspect, and fourth, that is often crucial when deciding whether or not to litigate a dispute. So in conclusion, we have I have mentioned four general benefits of litigation. The first one was international litigation offers the opportunity to focus on the law as the means to solve or resolve an international disputes and prevent economic or power interests from prevailing. Second, litigation of conflicts can result in a total recognition of the claim of a state. Third, litigation might be the best venue to solve a historical controversy. And fourth, the discharge of responsibility from the shoulder of the state and give that responsibility, a legitimate responsibility, to the ICJ or any other international court or tribunal. There are other scenarios in which states submit their cases to international courts or tribunal with the intention, for example, of compelling the other party to negotiate and resolve a conflict in parallel to a judicial process. For example, and then again, I'm presuming that this was the case in the process between Timor and Australia. On the 17th of December 2013, Timor-Leste initiated a proceedings against Australia regarding the seizure of and subsequent detention by Australian agents of documents and data and other property that belonged to Timor and over which Timor claimed to have a right to protect under international law, and which were actually in possession of Timor legal advisors in Australia. So Australia claimed to have acted, because they took the documents and the data, and Australia claimed that they have acted under an order issued under Section 25 of the Australian Security Intelligence Organization Act of 1979. Timor claimed that the seized items included documents and data containing correspondence between its government and its legal advisors on a pending arbitration under the 2002 Timor Sea Treaty between the two countries. So in other words, Australia seized documents from Timor's legal advisors, who are located in Australia, that were related to a maritime arbitration that was pending between the two countries. So in this process, and as you can imagine, Timor submitted as well a request for the indication of provisional measure in order to protect its right and prevent Australia from using this document and data against its own interest in the proceeding that was pending. And after hearing the parties, the court actually issued an order on the request for the indication of provisional measure that you can read on the website of the court. But what is important here is that in the end, the parties informed by a joint letter to the court, that's September 1, 2014, that they wanted to postpone the hearings of the case. And why? Because they wanted to seek a friendly solution, which gradually took shape as the negotiation process advanced. And then on March 2015, Australia informed the court that it was going to return the documents to the Office of Timor lawyers. And by doing so, because that was actually the merits of the order of provisional measure, and by doing so, it requested the court to actually modify the order of provisional measure, which the court did. And already a couple of months later, in June 2015, Timor informed the court that it wanted to suspend and discontinue the proceedings. Australia did not oppose, did not raise any objection to this request, and the case was discontinued. So this is a clear example on how a proceeding before the international court or any tribunal can be highly effective without the need to actually reach a judgment on the merits, but rather as a means of pressure to negotiate or resolve international legal dispute. There is also one additional scenario where the parties make use of the available mechanism that are contained, that I mentioned, for example, in Article 33 of the UN, but also in different treaties or conventions, and they are not successful. So they cannot obtain any result, and therefore they need, or the state need, to go to litigation. A recent example of this, where a case where the state actually used the conventional or tried to use the conventional mechanism available prior to submitting a case to the International Court of Justice, is the application of International Convention on the Elimination of All Form of Racial Discrimination case between Qatar and the United Arab Emirates. According to the convention, and I'm referring here to the Convention on the Racial Discrimination, two preconditions must be met before the court can be seized by any of the parties. The first one is that the dispute must be about the interpretation and the application of the convention. And secondly, the dispute must not have been resolved by negotiation or any of the other mechanisms that are indicated in the convention. So Qatar informed the court in its application that the conflict could not be solved by any of those mechanisms, meaning negotiation or any other mechanism that is contained in the convention, which, as I said before, in this case, are preconditions that must be met before the jurisdiction of the ICJ can be activated. So, and because Qatar couldn't reach any solution to the conflict with these mechanisms, it had to proceed and file a case against the United Arab Emirates before the ICJ. And one last example that I would like to mention is the case of Georgia versus Russia, because this has become a classic case on this topic, given that it was the first case in which the International Court of Justice, decided that it had no jurisdiction because one of the preconditions, being negotiation in this case, had not been met at the time of the filing of the case by Georgia. So, as we have learned today so far, there are several factors to take into consideration when deciding how to proceed and which means or techniques to use to solve a legal dispute between states. It is important to remember as well that two or more mechanisms can be activated in parallel, and in fact, one can influence the other. It is also possible that the mere existence of a judicial process can assist the parties or the states in their negotiation and expedite the adoption of a political agreement. We saw that right now in the case between Timor and Australia, and all the other scenarios that are possible here. To sum up, I would like to highlight the similarities and differences between both of the mechanisms, negotiation and judicial resolution. And regarding the similarities, it is important to remember that the outcome of negotiation and litigation are somehow both a little bit uncertain. Both mechanisms are dynamic processes. Both mechanisms are long somehow, so they give some room to change of the claims and the potential results, and the result of which, of course, are adapted through the process and the progress of the negotiations or litigation. So even if one could argue that there is a possibility to foresee the result in the litigation process, might be true, but not in all international legal disputes. Some of them are more clear, especially those that benefit from a high number of cases that has been decided on the topic. So you have certain kind of predictability of what the outcome could be. That would be, for example, maritime delimitations, for example. There are other examples, but yes, there is small room for state to envision what the result can be, but still that the result would be a little bit uncertain, similar to negotiations. So the differences focus on the formal aspect of the litigation, of course, as opposed to informal, which of course is just trying to describe here, but there's nothing informal of negotiation. But what I'm trying to say here is that negotiation, normally the agreement, the result of a negotiation process, can be adopted or not by the states involved in the negotiation proceedings. But with litigation, it's different. When you go to litigation and the court decide a case, then you have to accept the judgment of that court. There is not an option. You cannot say at the end of the litigation process, when the court issue its ruling, you cannot say, I do not accept these terms. And that is possible in the negotiation. So that's a formal-informal aspect that make a huge difference, and which is perhaps one of the most important things to consider when you are deciding whether negotiate a dispute or whether litigate our disputes. So I think that I'm going to stop here. I know that we are going to have some minutes for a Q&A session. So yeah, thank you very much. And I hope you enjoyed the conversation today.
Yeah, of course, sir. It was very, very knowledge enriching, and a student must have, got a good, practical aspect of international law. There are, a few questions. Most of them, I think you have cleared all the, practical aspect, how ICJ works, and how, what is the importance of sovereignty, and if they approach to the ICJ, then what could be the consequences of the relationship and all. So, yeah, sir, one of our students named Athira Nair, sir. So he has asked that, could you please explain the role of treaties in the settlement of international disputes?
Yeah. Okay. Should I also refer to the first point that you just mentioned? I think that I would like to clarify from the very beginning that the International Court of Justice is there, exists to solve international legal dispute between states. That's one of the mandates. The other mandate is to issue advisory opinion, which does not the non-contentious jurisdiction of the court. But I'm going to focus on the first one, which is to solve this legal dispute between states. That's the mandate of the court. So we shouldn't see the court as a room that you don't want to go in. I mean, you want to use the tools that are there. You want to use the law to solve international dispute instead of using the force or means to solve legal dispute with states. So I think that the conception or the idea that going to litigation before the ICJ is somehow an action that could affect the relationship between states is wrong. To the contrary, I think that we should welcome this type of proceedings, and perhaps even more, the state should use the court more often if they cannot find a solution between them, because there is nothing wrong on going to a judicial body and ask them to resolve a legal controversy between state by analyzing the evidence, by applying the relevant international law. What's wrong with that? There's nothing wrong with that. So of course you may lose some of the elements, but yeah, those are the rules of the game. You cannot always win, as I said before. Otherwise, it wouldn't be negotiation. It wouldn't be the peaceful resolution of dispute. It will be always one trying to impose its will on the other, and it will be like that all the time. It will be chaotic. So I think that we should definitely celebrate the existence of international legal tribunals, and we shouldn't have this negative preconception of the work they do. As I always say, if a case at the national level goes to the Supreme Court, you don't say, wow, it shouldn't have gone to the Supreme Court. No, you say, okay, now it's going to the higher authority, and let's see what they have to say. So why do we think about that like that with our own Supreme Courts? But when we see a case going to the ICJ, then we start thinking politically. We say, oh no, it's going there, so it must be wrong. It's going to affect the relationship with the states. No, I mean, we have to be mature here. We have to be, this is the result of a negotiation process that took many decades and years. This is the evolution of international law. This is the evolution of international community as a unit. And we should accept and celebrate this type of forums. So I think that, because you mentioned something about how this affects the relationship between the states when you come to the ICJ, and I just wanted to clarify that from the very beginning. Now, explain the role of treaties. Well, as I said before, I think one of the most important principles of international law is the principle of consent. So the International Court of Justice, for example, can only resolve cases between states and can only resolve cases when the party have accepted the jurisdiction of the court to resolve a dispute. And normally, you accept that to treaties. So there are different ways to accept the jurisdiction of the court. You can accept it by the optional clause, which is pretty much what's indicated in Article 36 of the Statute of the Court. Then you can accept it to a special treaty. That is there are some treaties that exist that are focused solely on the resolution of international legal disputes. That's, for example, the Pact of Bogota in Latin America. So if you sign that agreement, then you are accepting the jurisdiction of the court to solve any type of X disputes. So it could be general treaty provision, or it could be a specific treaty provision, like the one I mentioned here on the Convention of Racial Discrimination. So that treaty has a clause that indicates that in case of any disputes, if they cannot negotiate, if they cannot solve the dispute through negotiation of any other of the mechanism available in the convention, then they can go to the court. So that's the importance of the treaty in this case, because it provides the jurisdiction to the International Court of Justice to solve a dispute that is related to the interpretation and application of the convention. And then you have also, and this is actually a third example of the kind of jurisdiction that the court has, and is with treaties are on specific topics, and they include clauses that provide jurisdiction to International Court Tribunal. So that's the importance in terms of jurisdiction, but of course, in terms of the bigger topic, which is pretty much the settlement of international legal dispute, what it represents is agreement, I think. What it represents is a group of states sitting together and agreeing that if any dispute arises between them, then they will use the peaceful settlement mechanism to solve the dispute instead of deciding on an ad hoc basis on how to solve a specific dispute, which could be dangerous, of course, because then you cannot envision the mechanisms that you have to solve disputes with your neighbor, with the other states. So with this, you pretty much have all the rules stated and recognized in a treaty body, and that it has been signed and it's legally binding between the states that are part of that treaty in itself. So that's another role, of course, of the treaty, is pretty much the rules that govern the relationship between different states. It could be one, it could be two states, it could be a multilateral treaty, so it could be a universal treaty also, and that only defines who will be, not affected, but who will be part of the treaty, the multilateral, the universal, or the bilateral aspect of it. But in terms of substance, yes, I think that's what really matters here. So it will be, first of all, defining which international court tribunal will deal with any dispute that relates to the interpretation of that specific treaty, and it also provides clear rules to the states in case of something of that happen. And perhaps a last point here I have to say, because I have referred mostly to the case law of the International Court of Justice, but the International Court of Justice is one. It is the principal judicial organ of the United Nations, but you also have the International Tribunal for the Law of the Sea, for example. You also have arbitral tribunals, and states are free to decide where to go. And that's, again, the principle of free choice that is manifested through the principle of consent when they decide where to solve their international legal disputes.
Thank you, sir. There is one more question. Is there any hierarchy or a priority amongst the various methods of peaceful settlement of disputes that usually, state adopts?
I think that if you are talking about hierarchy, if the person who is asking this question has in mind Article 33 and the way that it is, that all the mechanisms are mentioned, then the answer is no. And I think that I mentioned that at the very beginning of the presentation. The answer is no. These are mechanisms that are all available. So states can decide if they want to negotiate a dispute, and they can do that. They can also decide that they want to go to conciliation or mediation without going to negotiation if there is no treaty obligation. So you have to understand that. If there is no treaty obligation to solve a specific dispute, first negotiation, second conciliation, and third judicial settlement, if there's no such a provision, then states are free to decide what to do bilaterally. And there is no hierarchy in that. So you can go directly to an International Court of Justice. You can also go directly to a table and negotiate an international legal dispute. So there is no hierarchy in that scenario.
So can we have a few more questions, if you permit?
Mm-hmm. Yeah. Yes.
Yeah. One of our students named Punit Jangir, he has asked that, can you please comment on recent US-China trade dispute and how International Court and WTO can play as a mediator in that? Because of this dispute, many things are affected at large scale.
Mm-hmm. Well, I think that, yes.
Yeah, that's, I mean, he wants to hear from.
Yeah, well, mediator, I don't know if that's the right word to use here, because again, as I said before, if you go to a judicial body, what you're asking is the judicial body to exercise its judicial functions. So it's not going to mediate in a sense that it will assist the parties to reach a solution. No, what it will do, it will listen to the parties and reach to evidence, analyze the evidence, the law, and then pronounce in a form of a judgment. So that's different. But what is important here, because I think that there is no merits in going into the details of this dispute, but what is important is that international courts, WTO or arbitral tribunals, Tribunal for the Law of the Sea, can only decide within the limits of the application. What does that mean? That they can only decide within the limits of the dispute as has been defined by the parties that submit the case, that file the case against the other state. So there is certain limitation. It's not like you can go to an international court, file a case, and the court has freedom to decide whatever they want. No, they can only decide within the limits of the dispute as has been determined and defined by the party that is filing the case. Also, if the party that is filing the case exceeds and goes beyond the dispute as can be submitted to the court because of the jurisdiction, of the title of jurisdiction, let's say a treaty or a specific treaty or something like that, then the court actually might even reject not exercise a judicial function, because it will consider that it doesn't have jurisdiction over that dispute, or the other party most likely will actually submit preliminary objection to the jurisdiction and admissibility of the dispute, because it goes beyond the jurisdiction that has been consented by the parties to any dispute. So how can this affect, because the question, I don't have it anymore in front of me, but how can this affect the larger image or relations, large scale? Yes, so it is large, but it is large in terms of ramifications. But in terms of dispute, it can only be within the limits that has been determined by the parties to a specific dispute.
There is one more question about the awareness or the field of international law and is very few, like budding lawyers and all opt for more criminal practice than the international litigant. So can you please throw light on that? Why less number of the lawyers do specialization in international law compared to the criminal, and the lack of the awareness in the field of litigation in international law?
Yes. If the person who is asking this question is referring to criminal international law, then you're talking about international lawyers as well. So it's international law. Criminal law is international. Yes.
Yeah, so he is ultimately, a kind of like whether a civil advocate or a criminal or an international, who is visually practicing in the,
yes, well,
migration aspects or international aspects like that.
Yes. No, I think that you're right. I mean, not everyone is familiar with the international arena or actually practicing international law properly. But I think that's changing. That is changing really fast. You have to understand that, for example, the International Court of Justice issued its first ruling in 1946. So after the Second World War, it was the new court started. So that's probably 2-3 generations before us right now. And before that, there weren't that, I mean, at that moment as well, there weren't that many states that were party to the United Nations. So it was just a group of states that decided that, and a group of states that had, their people participating in this negotiation that had certain type of capability, legal thinking, to start exercising that field of law. Exercising, not reading, not writing, but actually litigating before the international courts. At the very beginning of the court, you also, if you go back, or if you go to the website, you will see that the first cases were pretty much focused in Europe or also the United States against the Soviet Union. So funny, because at the very early stages of the court, the most active clients, let's say, of the court were actually European countries and the United States. Now it's different. But at the very beginning, it was like that. So it is a little bit not too difficult to understand why the expertise has focused in France, UK, and the US, because pretty much of this, you still have professors, well, probably some of them, not much, but that actually participated at the very early cases of the International Court of Justice, let's say. And also in terms of arbitration and, what is commercial investment arbitration is a little bit different, because this is a new field that has been developing mostly, it has increased considerably the amount of cases during the last 30 years. And there is a lot also of Latin American countries that has been, especially Argentina, that has been involved in this type of proceedings. So they are creating a new generation of international lawyers. Now, it is true that some states don't have many, but it is because also they don't engage much in this international litigation, and they have decided to resolve their dispute more in a bilateral way, so negotiation instead of triggering litigation on an international level. So, however, and if I may make a last point, now the big change of paradigm is that you don't have to be you don't have to go to an international court or tribunal to exercise international law anymore, because right now, especially in the field of climate change or environmental law, you can actually exercise international law at the domestic level, because when you go to a domestic court to actually litigate a case that is related to climate change or environmental law, you are going to use a domestic lawyer. You are going to use international law at a domestic level. So nowadays, more with the globalization and the integration of different fields of international law, being human rights, environment, climate, etc., most of the new lawyers will be international lawyers at the domestic level, which I think it is very impressive. And I think that it requires us to be a little bit more conscious about it, because our judicial system also need to update a little bit, because they need to understand more international law if they are going to decide these kind of issues. And you have many cases right now, especially one that was decided here in the Netherlands, which is the Urgenda case, but it has also cases in Norway and France. Right now you have more international cases that are being filed also by the next generations concerning future generation, intergenerational equity principles, human rights, etc. So there is a lot of potential here.
Yeah, correct. So one more question. Which one of the methods of peaceful settlement gives a more binding decision, or rather being an advisory this thing?
Yes, so I only address today two of the methods, negotiation and judicial settlement of disputes. And between those two, it's just International Court of Justice. So judicial bodies are the only one that provide binding decisions, so not negotiation. And yes, so the International Court of Justice, for example, whatever the court decides is final, binding, without appeal. And so states there's not much you can do if you go to the court, and the International Court of Justice, but also Tribunal for the Law of the Sea and Arbitral Tribunal. When they decide something, then that is the final decision. There is no, there is not the equal of a Supreme Court in international arena. So you go, it is decided, and that's it. Then it's about an implementation. The only option you have, if the other party does not comply, is the UN Charter indicates in Article 94.2 that you can actually request the United Nations to, you can request measures if the other party does not accept or is implemented in the court. But that is a post-judicial process and is political in nature. So it's not a legal process.
Yeah. So throughout the session, we are getting the comments like it is very, inspiring session, very, informative session, great session. So, and there are many questions, which you already have answered during your, this talk, and even when you are answering. So there is many similarities in, many questions and like that. Like, there is one more question, which is, I think you already answered, that how should one choose the suitable means of the settlement and all. So there are many questions and many, this thing that they are very, similar that you already have answered and during your talk and in the QA session also, sir. So thank you very much, sir, for, accepting our invitation and delivering a special talk on international law, especially on the ways of how to, peacefully settle the international dispute through both the ways. Maybe it's a negotiation and judicial settlement. You have correctly explained us the advantages and all, how ICJ's jurisdiction helps, countries, and how it removes the inequalities, like whether state is politically and diplomatically strong, or it's in a underdeveloped countries or like that. But at the ICJ, everyone gets the equal proceedings, and through the judicial settlement, through the support of the law, how this disputes can be settled and all. We are from the Faculty of Law, GLS University. We are very thankful to you, sir, that you accept our invitation from your busy schedule. You have accept our invitation and deliver the special session on international law. There is one shloka in our Sanskrit India that ayam nich paroveti karna laghu chetasam udar charitanatu vasudhaiva kutumbakam, which means that everyone does one or other thing for themselves, for oneself, and for their family. But there are so generous people on this planet Earth, or a Mother Earth, who considers the whole world as one family. And we truly express our gratitude from Faculty of Law, GLS University, that we are very thankful that, on a single, email and message, you have accepted our invitation and delivered so inspiring and knowledge enriching session at our e-platform of our university. Thank you very much, sir. Very thankful.
No, thank you very much. I appreciate the invitation, and it has been a great pleasure. In any case, I thank you all for being here on a Saturday. That I don't know if the perfect Saturday includes a 1 hour talk about international law. So I appreciate all the participants and the kindness of your time, and it has been a pleasure. Thank you.
Thank you very much.
Bye-bye.